Good afternoon and welcome to the Public Service Commission of South Carolina. We are reconvening the hearing in docket number 2023-89-E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. As we left this morning, there were some discussions that were going to go on. Do we preliminary matters before we begin? Mr. Hall, I see your light.
Yeah, thank you, Commissioner Belzer. I think, where we left off, we had wrapped up the settlement testimony, and we're going to move into the regular testimony. If it wasn't clear from the stipulation we filed, the department only intended to put in the settlement testimony of Mr. Rothschild. Therefore, we would withdraw the pre-filed direct and surrebuttal testimony that was previously filed in the matter. And the department would have no more witnesses at this time.
Thank you, Mr. Hall. I think that clarifies things. I don't know that it can be physically withdrawn from the DMS for FOIA reasons and other reasons, but
I was not certain of the commission's procedures for that. I just want to make it clear that we are asking to withdraw it and do not intend to put in his direct and surrebuttal testimony.
Thank you, Mr. Hall. Appreciate that. Mr. Cooper, you've risen.
Yes, Chair Belzer. Well, at this time, likewise, the company has a preliminary matter, and we think that preliminary matter has been resolved in talking with the parties, and so the company at this point would seek to withdraw its preliminary motion.
And that was the pending motion.
Yes,
Correct.
Chair Belzer.
All right. I need to ask some questions, and I think if I don't cover everything to other commissioners' satisfaction, there may be questions from commissioners with regard to this, if that's okay. So, first of all, are the parties, and this is going to everyone, but are the parties aware that they had the opportunity to avail themselves of a remedy of forwarding the motion to the Administrative Law Court?
Chair Belzer, the company is aware of that.
Okay. ORS and DCA and Mr. Lavonga. Anybody else? Everybody's aware of that?
Yes.
Yes, Madam Chair.
Mr. Lavonga?
Yes, Chair Belzer.
And are the parties freely and voluntarily waiving that possible remedy with regard to the motion?
The company is, yes.
Mr. Lavonga?
Yes, we are.
DCA?
Yes.
ORS?
Yes, Madam Chair.
Okay. Is that motion withdrawn with prejudice?
Yes, Chair Belzer.
Okay, thank you. Has any party been promised anything, in any way coerced or stronghold held to come to this resolution?
The company has not.
Mr. Lavonga?
We have not, Chair Belzer.
DCA?
No.
ORS?
ORS has not.
Okay. Are the parties satisfied that this pending motion, which let's call it a preliminary matter, has been resolved?
Yes, Chair Belzer.
Mr. Lavonga?
Yes, we are.
DCA?
Yes.
ORS?
Yes, Madam Chair.
Just a moment. With regard to any issue with this preliminary matter, is any party concerned with the commission not being able to listen to and resolve this matter in an unbiased manner, impartially, and free from any kind of outside influence?
The company is satisfied that the commission can consider this matter in an unbiased manner and resolve this matter.
Thank you. Mr. Lavonga?
We
Any,
agree that the commission can resolve the matter.
and when we say the matter, we're talking about the case in the docket.
That's correct, Chair Belzer.
Okay, let's just be clear.
And likewise, the department has no concerns about the commission's impartiality and ability to decide this matter.
And Mr. Huber?
Same from ORS.
Thank you. Commissioners, any questions for parties with regard to this?
Madam Chair,
Commissioner Irvin?
thank you. And just so that we're clear, the company in some pre-filed motions had alleged some ex parte communications that allegedly took place. And one of those alleged ex parte communications that was disclosed was a communication to Mr. Rothschild, who's a witness for the Department of Consumer Affairs. And there may be others that we don't know about or don't have sufficient facts to develop. But regardless, does the company understand that by waiving and giving up its rights to take these alleged ex parte communications and any alleged prejudice to the administrative law court under South Carolina Code Section 58-3-270 annotated, do you understand that you're giving up any and all rights to pursue the allegations of alleged ex parte communications and or prejudice? Does the company understand that? I need a affirmative answer.
Yes, sir. Commissioner, counsel is conferring.
Thank you.
Commissioner Irvin, members of the commission, the company it's the company's position that it is, this matter is resolved, and therefore it is withdrawing its motion. It is waiving rights to seek any further remedies.
Are you waiving the right to appeal the matter based on any alleged ex parte communications that have come to light to date?
Yes, for any issues that have come to light to date. That's correct, Commissioner.
And so you understand that if we did adjourn, we could toll the statutory, or we could toll the time so that the parties in the company would not be prejudiced. We could simply toll the time, give you a sufficient amount of time to file your petition with the administrative law court and have any and all allegations, testimony, and evidence that you would like to present to that independent tribunal for full and fair determination on the merits of any alleged ex parte communications that you referenced in your motions. You understand you're giving up that right?
Yes, Commissioner.
Have you communicated that to your client who has authority to make that decision on behalf of you?
Yes, Commissioner. My client, Duke Energy, has given me authorization to stand before you and make these representations.
And so they're bound by your agreement to waive and give up your rights to go to the administrative law court as well. Is that correct?
Yes, Commissioner.
Right? And do you believe that this action that we're talking about now will protect the integrity of the commission going forward to address any and all issues in this docket in a fair and impartial manner?
Yes, Commissioner.
You're satisfied that commission could still serve as fair and impartial tribunal resolving any and all issues in this matter?
Yes, Commissioner.
Do the other parties agree with the responses that I've heard from Duke's attorney?
Just a moment, Commissioner. Mr. Lavonga, do you have a response?
Yes, Commissioner Irvin, we agree.
DCA, do you have a response?
The department agrees.
ORS, do you have a response?
We agree, Madam Chair.
Thank you.
And
Commissioner?
so, just in conclusion, I find that all parties and their attorneys of record are in complete agreement with the stipulation that company has withdrawn any allegation as it relates to alleged ex parte communications and any resulting prejudice based on the testimony and responses of their attorneys of record. Thank you, Madam Chair.
Thank you, Commissioner Urban. Commissioners?
Madam Chair,
Commissioner Thomas?
thank you. I have a very simple non-attorney question. I just want to make sure that I understand that all of the parties are comfortable that we as this commission can move forward based on everything that's happened so far and treat everyone fair, and that you believe that we are capable of coming up with the fair outcome and conclusion in this case.
Mr. Cooper?
Yeah, Commissioner, the company is satisfied with that.
Mr. Lavonga?
Commissioner, we're satisfied as well.
Mr. Hall?
Yes, Commissioner Thomas, that's correct.
Mr. Huber?
ORS is satisfied also. Thank you.
Okay, and I have one more question. I believe what we've been talking about here is item number 27 in the stipulation. Is that correct?
It
Settlement
relates to
agreement.
item, it certainly relates to item 27.
So then is effectively item number 27 removed, or I don't understand how that fits into if we vote to approve or not approve of the comprehensive settlement agreement.
Commissioner Thomas, I'll let my other counsel speak as well, but the department's position would be that essentially that provision is moot at this point. There are no other pending motions before you. If it's something that feel needs to be revised, I think we'd be happy to do so. But at this time, I think that paragraph 27 simply is not applicable anymore. That's a part of the reason we clarified this. And also going back to the list of witnesses that you saw where it said for Mr. Rothschild, a settlement testimony only, just trying to clarify that issue as well. But at this, the department's position would be paragraph 27 has no applicability anymore.
What about the other people that signed off on the settlement agreement?
That would be the position of the company as well, Commissioner. If you'd like for us to make a motion to strike that paragraph, we can, but we don't think that's necessary. We agree with the DCA that it's moot or not applicable anymore.
Mr. Lavonga, do you have a position?
Yes, we agree that the provision is moved.
And Mr. Huber for ORS?
Yes, we agree that paragraph is moot or no longer applicable.
Thank you.
And I'm not going to give any sort of a legal opinion on whether that thing should be modified or not. I'm not an attorney. If somebody else thinks so, that's fine. That's all I had.
Thank you, Commissioner. Anything further? Thank you, parties, for your presentations this afternoon. Are we ready to, is there anything else? Mr. Huber, you had something this morning. Do you want to present that now, or do you want to do that in the morning? We're going to go till about 4:30 is kind of our timeline for this afternoon.
I can do it in the morning to the extent it's still needed.
Thank you. Mr. Cooper, I think we're back to the company with witnesses. Is that correct?
That's correct, Chair Belzer. So at this time, Chair Belzer, members of the commission, we have witnesses that we would put on a panel, witness Spiros and witness Moore. Witness Spiro and Moore would talk about kind of post-bond mechanics. So this would be the mechanics of a true-up, the 30, 60-day matter, the ability to allocate across customer class the cost of the recovery. And so we are happy to stipulate their testimony into the record. We're happy to call them as a panel if you may have questions.
Let's call them as a panel if you don't mind.
Just wanted to clarify.
Thank you, sir.
So at this time, the company would call Nicholas Spiros and Jacqueline Moore to the stand.
Mr. Cooper, may I ask another question? I just wanted to note for the record that I believe the late filed exhibit, which was marked as hearing exhibit 2, has been filed. I think we talked about that some this morning.
I believe it's here in Exhibit 7. Is that correct, Chair Belzer?
Yes, it is. I just wrote it down wrong on my sheet. Hearing exhibit 7 has been filed.
That's correct. It has been filed.
Thank you.
Raise your right hand, please. Do you swear from the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Spiros, we'll begin with you. Would you please state your name for the record?
Yeah, my name is Nicholas Spiros.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as Director of Accounting.
Have you prepared or caused to be prepared under your supervision direct testimony of 14 pages that was previously filed with the Commission on May 31st, 2023 in this docket?
Yes, I have.
Do you have any changes or additions to your pre-filed direct testimony?
I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Have you prepared or caused to be prepared under your supervision 2 exhibits to your direct testimony labeled as Spiros Exhibit 1 and Spiros Exhibit 2 that were previously filed with the Commission as attachments to your pre-filed direct testimony in this docket?
Yes.
Do you have any changes or additions to your exhibits?
No.
Chair Belzer, at this time I move that the pre-filed direct testimony and exhibits of Mr. Spiros be admitted into the record as if given orally from the stand.
The pre-filed direct testimony of witness Spiros will be entered into the record as if given from the stand, and Mr. Spiros' exhibits attached to that pre-filed testimony will be a composite exhibit marked for identification as Hearing Exhibit 10 and received into the evidence of this case.
And Mr. Spears, have you prepared or caused to be prepared under your supervision rebuttal testimony of 10 pages that was previously filed with the Commission on August 10th, 2023 in this docket?
Yes, I have.
Do you have any changes or additions to your pre-filed rebuttal testimony?
I do not.
If I asked you those same questions here today, would your answers be the same?
Yes.
And Chair Belzer, at this time, I move that the pre-filed rebuttal testimony of Mr. Spears be admitted into the record as if given orally from the stand.
Mr. Spiros's pre-filed rebuttal testimony will be received into the record as if given from the stand.
Mr. Spears, have you prepared a summary of direct and rebuttal testimony?
Yes, I have.
Would you please deliver that at this time?
Yes, I will. Good afternoon, Chair Belzer and members of the Commission. The purpose of my testimony is to propose the mechanism and corresponding form to be used for making periodic formula-based true-ups to the company's proposed storm recovery charge and to present the accounting entries that will be required for the same. There will be a single storm recovery charge dedicated for storm recovery bonds issued on behalf of DEP. The storm recovery charge will be paid by all existing and future retail customers receiving transmission or distribution services or both from DEP or its successors or assignees. The storm securitization statute requires the company to periodically true up this charge to ensure that customers pay no more or no less than is what is required. As a result, the company must file with the Commission at least annually an application requesting administrative approval to make the applicable true-up adjustments. The company proposes to file at least semi-annually or quarterly beginning 12 months prior to the scheduled final payment date of the latest maturing tranche of the storm recovery bonds of a specific series, a new estimated revenue requirement for the company's storm recovery bonds. In addition, the semi-annual true-up adjustment, the company will, acting as servicer for the storm recovery bonds, seek authority to make interim true-up adjustments. These true-up adjustments will be made at any time as necessary to ensure the recovery of revenues sufficient to provide the timely payment of the storm recovery bonds associated with the financing cost. As for the financing itself, the company will conduct the storm recovery financing through a special purpose entity or SPE. The SPE will be created solely to facilitate the storm recovery cost financing and would be wholly owned subsidiary of the company. The SPE and the company will maintain separate accounting records. The company is proposing to sell the storm recovery property an approximate amount of $170.6 million to the SPE as approved by the Commission in docket number 2022-256-E. Additionally, all paid or accrued upfront financing costs, primarily bond issuance costs, will also be included in the amounts funded through the bond financing at the SPE. The storm recovery charge collections will be remitted to and recorded as revenues at the SPE. After all storm recovery bonds and ongoing financing costs have been paid in full, the relevant storm recovery charge will no longer be billed or collected from customers. Any remaining amounts held by the special purpose entity, exclusive of the amounts in the capital subaccount representing the equity contribution, together with any return on the capital subaccount, will be remitted to DEP as applicable to be booked to a regulatory liability, and it will accrue carrying costs at the company's weighted average cost of capital and will be credited back to customers in the company's next general rate case proceeding following the maturity of the storm recovery bonds. Finally, I've reviewed the terms of the comprehensive settlement, and I am familiar with the terms and conditions contained therein. I support the settlement and respectfully ask the Commission to approve it, and this concludes the summary of my pre-filed testimony.
Thank you, Mr. Spiros. Ms. Moore, will you please state your name for the record?
My name is Jacqueline Moore. I'm a business. Go ahead.
And by whom are you employed in what capacity?
I'm employed by Duke Energy Business Services as a subsidiary of Duke Energy as a rates and regulatory strategy manager.
Excuse me, Ms. Moore, I'm over here. Sorry, I know it's hard to find us. Could you move that microphone a little bit closer if possible? I know it's hard when you've got your notebooks and your notes in front of you. Thank you, ma'am.
And have you prepared or caused to be prepared under your supervision direct testimony of 11 pages that was previously filed with the Commission on May 31st, 2023 in this docket?
I did.
Do you have any changes or additions to your pre-filed direct testimony?
I do not.
If I asked you the same questions here today, would your answers be the same?
They would.
Have you prepared or caused to be prepared under your supervision 2 exhibits to your direct testimony labeled as More Exhibit 1 and More Exhibit 2 that were previously filed with the Commission as attachments to your pre-filed direct testimony in this docket?
I did.
Do you have any changes or additions to your exhibits?
I do not.
Chair Belzer, at this time, I move that the pre-filed direct testimony and exhibits of Ms. Moore be admitted into the record as if given orally from the stand.
Ms. Moore's pre-filed direct testimony will be entered into the record as if given from the stand, and Ms. Moore's pre-filed exhibits 1 and 2 that were attached to her direct testimony will be a composite exhibit marked for identification as hearing exhibit number 11 and received into the evidence of this case.
Thank you. Ms. Moore, have you prepared or caused to be prepared under your supervision supplemental direct testimony of 4 pages that was previously filed with the Commission on July 21st, 2023 in this docket?
I have.
Do you have any changes or additions to your pre-filed direct supplemental testimony?
I do not.
If I asked you the same questions here today, would your answers be the same?
They would.
And have you prepared or caused to be prepared under your supervision 2 exhibits to your supplemental testimony labeled as More Supplemental Direct Exhibit 1 and More Supplemental Direct Exhibit 2 that were previously filed with the Commission as attachments to your pre-filed supplemental testimony in this docket?
Yes.
Do you have any changes or additions to your exhibits?
I do not.
Chair Belzer, at this time, I move that the pre-filed supplemental direct testimony and exhibits of Ms. Moore be admitted into the record as if given orally from the stand.
Ms. Moore's supplemental direct testimony will be read into the record as if given from the stand, and Ms. Moore's supplemental exhibits 1 and 2 will be a composite exhibit marked for identification as hearing exhibit number 12 and received into the evidence of this case.
And Ms. Moore, have you prepared or caused to be prepared under your supervision rebuttal testimony of 6 pages that was previously filed with the Commission on August 10th, 2023 in this docket?
I did.
Do you have any changes or additions to your pre-filed rebuttal testimony?
I do not.
If I asked you the same questions here today, would your answers be the same?
They would.
Have you prepared or caused to be prepared under your supervision 2 exhibits to your rebuttal testimony labeled as More Rebuttal Exhibit 1 and More Rebuttal Exhibit 2 that were previously filed with the Commission as attachments to your pre-filed rebuttal testimony in this docket?
I have.
Do you have any changes or additions to your exhibits?
I do not.
Chair Belzer, at this time, I move that the pre-filed rebuttal testimony and exhibits of Ms. Moore be admitted into the record as if given orally from the stand.
Ms. Moore's pre-filed rebuttal testimony will be entered into the record as if given from the stand. Ms. Moore's pre-filed rebuttal exhibits 1 and 2 will be a composite exhibit marked for identification as hearing exhibit 13 and received into the evidence of this case.
And Ms. Moore, have you prepared a summary of your direct, supplemental, and rebuttal testimony?
I have.
Would you please deliver that summary at this time?
Good afternoon, Chair Belzer and members of the Commission. The purpose of my direct testimony is to demonstrate that the storm recovery charge rates the company proposes reflect appropriate rate-making principles and result in an equitable basis for recovery of the company's revenue requirements across and within customer class and rate schedule. My testimony also, 1, describes the changes in the company's retail electric rate schedules, quantifies the effects of these proposed changes on the company's South Carolina electric retail customers. 3, discusses how the company proposes to implement the storm recovery charge. And 4, describes other requested changes to the company's tariff. Specifically, my testimony focuses on outlining the steps followed in calculating the proposed storm recovery charge by rate class, which include utilizing the allocation factors from the company's most recent rate proceeding to allocate the revenue requirement to each customer rate class. Differences between the estimated and actual amount of storm recovery collection charges and the amount of interest, principal, and ongoing financing cost will result in an adjustment to the charge. The company will determine these adjustments through a true-up process. For example, at least semi-annually, a new estimate of revenue requirement for the company's storm recovery bonds will be calculated using the storm recovery charge true-up mechanism form that Witness Spiros presents in Spiros Exhibit 1. In addition, the company acting as servicer for its series of storm recovery bonds will be permitted to file for interim true-up adjustments at any time to ensure the recovery of revenue sufficient to provide for the timely payment of principal interest for the storm recovery bond and all ongoing financing costs payable in connection with the storm recovery bonds. My testimony also addresses the tariff revisions needed to implement the storm recovery charge for the company. However, the company will not seek commission approval of the tariff sheet until the final terms of the issuance of the storm recovery bonds have been established. My supplemental direct testimony, I update the variance factor and the calculation of the storm recovery charge by rate class presented in my direct testimony. In my rebuttal testimony, I address the direct testimony of South Carolina Office of Regulatory Staff witnesses Sieben, Wynn, and Collin with respect to several items related to the variance factor. The company agrees with using a weather normalization calculation that matches its most recent South Carolina base rate proceeding. This methodology includes the use of 30 years of weather normalization data in the calculation of the forecast variance factor. The new variance factor has been incorporated into the updated rate calculation in my rebuttal testimony. I also provide an updated securitization tariff that includes additional language and a description of the rate calculation, data sources, and variance factor. Finally, I make clear that the variance factor will be applied to all periods, not just the first 2 periods. The variance factor must remain in order for the company to maintain on an ongoing basis sufficient cushion to address lower than weather normal volumes that might otherwise require interim true-up adjustments. Although the company must apply the variance factor in all future periods, the impacts to customers should be small and approximate rates without the variance factor on average, subsequent to the first 2 periods. Finally, I have reviewed the terms of the comprehensive settlement, and I'm familiar with the terms and conditions contained therein. I support the settlement and respectfully ask the Commission to approve it. This concludes the summary of my pre-filed testimony.
Thank you, Ms. Moore. Chair Belzer, at this time, Witness Moore and Witness Spiros are available to answer any questions.
Thank you, Mr. Cooper. Parties have waived cross, right? It seems like a long time ago. But commissioners, questions for this panel?
I guess.
Commissioner Caston?
And good afternoon. And I'm pretty sure this probably isn't your question, but I don't know what to do with it, so you're all I got right now. How's that? In the hearing exhibit number 7, the very small print, net of tax weighted average cost of capital, shows 6.38%, I think, on the 10-year, 15, 20-year. And it's probably just a transposed number because I guess, rate case, the order.
Page. Can you identify the page?
Oh, yes, ma'am. It's, well, the page I'm looking at in particular is page 6 of 22, hearing exhibit number 7. And I think this is the 10-year storm securitization. And I just wanted, I guess, just to clear it up for the record, I think the original order, the rate of return was 6.83. So I guess I'm just letting that be known to just kind of verify it. I'm not sure what difference it would make. I mean, I can think of some mathematical differences it would make. I just kind of want to make sure that if we need to fix that, we fix it.
I think, Commissioner, may I clarify? I think on hearing Exhibit 7, he's referencing the line 10, under storm recovery charge model, and it's got 6.38%. And
Yes,
I think
ma'am.
he looked at recognized from the order that the order was 6.83%. Is that the issue?
Yes, Madam Chair.
And these may not be the witnesses to answer that.
Or may I ask this question, Chair Belser? The witnesses can answer whatever, however, but if they need time to consult, could they come back or, either update you during this? Okay. Yeah, I think if the company should be able to provide somebody else to address this question, but we'll
Mr.
get it
Cooper,
answered today.
I think this was Witness King's exhibit. And look, I'm not trying to put you in the spot. Don't expect you to give me a off-the-cuff answer. Just, take whatever time you need to just, verify it. Just make sure that's the number you intended.
Yeah, I think we can absolutely do that, just to verify that that number is correct.
And I'm sorry to just dump that on you, but that's really all I had, Madam Chair.
Thank you. Commissioners, questions? Vice Chair Powers.
Thank you. Ms. Moore, could you explain exactly it looks like a significant change in the variance factor from what was originally, and just explain what a variance factor is?
Yes, originally I filed in my direct testimony a 2.87% variance factor, and that was just an estimate using 1 year's worth of megawatt hour information. But we've changed that, and we're trying to we came up with a better process on how to risk adjust the forecast. So that adjustment factors now is based on 30 years of weather normalized data, and I think it's 4.97%.
Okay. And of course, that's 30 years back.
Yes, sir.
We obviously are seeing a lot of changes in our weather and stuff. This number is just an estimate. There's really a lot of this we just don't know at this point, isn't there?
Yeah, the variance factor is just trying to give us a band of reasonableness around the forecast. So we're trying to estimate the number of kilowatt hours or megawatt hours that we're going to achieve in the next collection period. And so that variance factor just gives a range. So this is below normal weather, so that range would be just below. So it would be more likely that we would achieve that megawatt hours so that we can make the collection amount.
If your change in the variance factor from what you originally forecasted to the new one, does that benefit ratepayers?
I think in the
Or
long
could
run,
it-
I think in the long run it will benefit ratepayers because they'll see less variation of that of their cost or the rate that's applied to that kilowatt hour charge.
Okay. Thank you, ma'am. Thank you.
Commissioners? Ms. Moore, does that 30-year calculation with the variance factor, is that intended to match, and maybe they don't even have anything to do with each other, but is that intended to match the 30-year weather normalization that I think ORS proposed and which is accepted in your rebuttal and in the stipulation?
Yes, we changed from originally our forecast group used 37 years of weather normalized data, and we agreed with witness Colin that 30 years was more reasonable because we used that in our last rate case, and it was an approved methodology.
And that was accepted in the settlement agreement as
Yes.
well? Is
Yes,
that
Chair.
correct? Okay, thank you. Mr. Spiros, how are you this afternoon? I think you might be the right person to ask this question. In the settlement agreement, there was an agreement between and I'm on page 6 of 18, if you have the settlement agreement. It's paragraph 11, and it pertains to the 60 days to report any mathematical errors or calculations in under the true up. And Duke and ORS have agreed to, after 3 semi-annual true ups, to try to reduce that to 30 days. Is that correct?
That is correct, Chair.
Is that a reasonable time frame for the company to actually and ORS to come together on whether there are any mathematical errors or?
Yeah, we believe it is. 30 days would be most appropriate, but I think the 3 true-ups does give us enough time to see what a true-up looks like, how the formulas are working. So I do believe, yes, that gives all the parties.
Is there benefit to the ratepayers by being able to reduce that time period?
The way I think about it is that we have a 6-month period that we're going to do a semi-annual true-up in. So there is a fixed period of time that we have to collect a certain amount of cash to meet those debt service obligations that we have. So by implementing a rate sooner, if there's a shortfall, there's a benefit for less volatility in that rate to go up and down over that 6-month period.
Okay.
So the sooner we can get a rate in, the sooner we can get that cash to meet that debt service obligation.
Okay, thank you.
Yeah.
And Ms.
Madam Chair, excuse me.
I'm sorry. Ms. Moore, I had one other question, and you can't laugh at me, okay?
Well,
I'm telling you right now, you can't laugh at me, but I just want to look at your tariff sheets, and I don't care if I'm actually in your rebuttal. And I know this is not the final version, because the final version, I think you indicated, wouldn't be filed until after placement and all the costs are known. You with me? It's actually, I think it's page 2 of 2. I'm on page 2 of 2 of your rebuttal exhibit 2. And the billing rate is expressed in cents per kilowatt hour. Is that correct?
that's correct.
Okay, so what do you have there for residential?
I have 0.502 cents per kilowatt hour.
So that's half a cent. Is that correct?
Yes, ma'am.
All right. And then for lighting, it's 1.370. So that's 1.37 cents. Okay. I always get screwed up on decimals and these factors and stuff. So I just want to make sure I'm looking at this thing right.
That's correct.
Okay. Thank you very much. I told you not to laugh.
I'm not laughing.
Vice Chair Powers.
Just one more question. Ms. Moore, just popped in my head. The 37-year original plan, was that designed so that it would include Hurricane Hugo? Because it does.
Used in the weather normalization of 37 years. Is that what you're asking? I think forecasting told me they just used more years because they thought it'd be more accurate.
Well,
It didn't have anything to do with the storms.
it cuts off right before Hurricane Hugo. It throws Hugo into that, which is a major, major storm. Thank you.
Commissioners, any further questions? Commissioner Carolee Williams?
Thank you. Ms. Moore, this may not be a question for you, but looking at the tariff sheet, can you tell me what will be on individuals' bills, or is that a question for Ms. Newhouse?
Yes, I can address that. We'll have a separate line item on the bill that says storm securitization cost, and it'll have the actual rate and the total amount that's calculated. And then there'll also be on the bill a description of the charge, saying that it was approved in a financing order and that there's a special purpose entity that owns the charge. As a matter of fact, we have a copy of the bill if you would like to see that.
I would love to see it,
Okay.
if that's
Great.
possible.
Yes.
Commissioner, we have copies of a redacted bill. If you'd like for me to also put it on the Elmo, if you think that would be helpful, I can do that as well.
That would be good to put it on the Elmo.
Was this included in someone's testimony? Glad I asked. Makes me wonder what else we don't ask for that you all are ready for. Will you walk us through it?
All right, okay. So if we look on page 2 of the bill,
Actually, I think it's 3.
this is a North Carolina bill. So in the right column, it's under important to know. There's a section called Storm Recovery Charge, where it says this bill was approved in a financing order issued to DEP by the NCUC to recover storm recovery property. As approved by the NCUC, a special purpose entity is the owner of the rights to collect the storm recovery charge, and DEP acts as agent collecting for the special purpose entity. So something similar to this, since this is in our billing system, would also be in South Carolina bills, except it will say the Public Service Commission of South Carolina. And then if you go to page 3, if you look in the section called Billing Details Electric, the next to the last charge is the storm recovery cost. And that gives the total kilowatt hours that the customer used, the rate, and then the charge is on the right-hand column, $2.96.
What would a customer who only sees electronic bills see?
They would see the same thing.
Okay. And was there any discussion about defining the time frame under which a customer would be obligated to be paying these charges? You know, the 20-year term.
Are you talking about a monthly bill?
On the
when
bill, it just strikes me as, and I know there's a balance between too much information and just the right amount. So I'm just asking if there was consideration to defining that it was a 20-year time frame, or where you were within the period of paying those off. It's not a forever cost, which I think is really important for customers to know.
I do know they cut the wording down quite a bit because there's only so much room.
Right.
But I do think what you're saying is important. I don't know if it can be reworded to add that, if that's something you think is necessary.
Well, I'm really asking if that's something you all consider, because I know every character matters, and I think it is worthy of consideration.
I'm not aware if it was in North Carolina.
Commissioner, if I may, I don't personally know the answer to your question, but I do recognize that on the bill itself, it does refer customers to a web page that gives them a lot more detail. I haven't specifically visited that page, so I'm not sure if it talks about the 20 years there,
Right.
but it seems logical that it may there.
And that may be the place for the information I'm talking about to go. I don't know enough to know. I really was just asking if you all considered that as you considered what was most important for a customer to understand when they're making, especially when it initially goes on the bill. Was there any discussion about that? How it's messaged?
Corporate comm is normally the entity that decides ultimately, I think, what goes on the bill. We put on there what we know needs to go on there, but I think they word it the way they need to.
Would you imagine, or would anybody know if there's communication planned for if this is approved, how that goes out so that people understand what's going on their bill, that it's a new charge, it's not a forever charge, those kind of pieces of information? Or is this outside of your realm?
Subject to check, that, subject to check. I think we do send out a bill message when this payment starts that describes more thoroughly what it's about.
Is there anybody who's going to be testifying yet to come that I can ask that of?
Possibly Witness Heath, but I'm not sure.
Okay. He's shaking his head. Thank you.
Is he a
And
yes or
thumbs
no?
up. I
Okay,
appreciate
good,
that.
good.
No further questions.
Commissioner Justin Williams?
Thank you, Madam Chair. Panel, thank you for being here today. I'm not going to ask too many questions simply because Commissioner Williams unpacked and explored some questions that I had about the bill. But I do want to make a couple of statements. I think the bill it has everything it should have on it. It's clear and easy to read. And if you take the time to do so and go to the links, you probably won't have too many questions. My concern, though, is sometimes, speaking for myself, I don't take the time to read. And in the event that you have a ratepayer that does not take the time to do the additional steps, I'm just curious to know, is there any thought or discussion about including the storm recovery charge on the first page?
I'm not aware of it.
Okay. Is that something, and if this is outside of your area, just let me know. I don't want to put you in a position to answer questions that you're not, that's not a part of your area of responsibility.
It's not, but I can inquire about it if you
Okay.
feel like that's important.
Okay. So I think we've heard testimony, and I think you may have been here, maybe you were not here, maybe you were watching online, that if one figure that has been stated, I think it's in the application, that there's a potential for approximately $41 million in savings if this stipulation or the application is approved. If I didn't know that by being in this hearing, or I didn't go to one of these additional links or steps, I don't get that from the bill. And it seems to me that that could be lost on ratepayers. Is that something that anyone that you know of has thought about in terms of communicate, if the stipulation is approved, something that has been considered and discussed?
I'm not aware if that would go on the bill or the website, as Witness Spears was talking about,
Okay.
where there's more detail.
Okay. All right. All right. Thank you so much, ma'am, for indulging me. I appreciate it. And did you say Witness Heath will probably be the person to ask that?
Yes, Commissioner.
Thank you so much.
Thank you, Commissioner. Before I lose track, Mr. Cooper, are y'all going to offer that sample bill into evidence? It's been published and given out.
Chair Belser would be happy to.
I just want to do it before I forget. So the sample bill would be marked for identification as hearing exhibit number 14 and received into the evidence of the case. Thank you, sir. Commissioner Thomas.
Thank you. And I'd just like to follow up on the questions by Commissioner Williams and the other Commissioner Williams. And I believe that it is very important to make it obvious somewhere on the bill that this is a savings. If this turns out, according to the application, to be on there for 20 years, I think that should be made very obvious that this line item is a savings. I don't know how to do it, but I think that's very important. And I don't know whether we'll have any oversight or input as to how it shows up on the bill. But I think that they have made excellent points. And I would strongly recommend that the company make it obvious that this is a savings. Thank you.
Madam Chair,
Commissioner Irvin is recognized.
I agree with Commissioner Thomas and Commissioner Justin Williams and Commissioner Carolee Williams that communicating with the ratepayer in the event that this petition is approved is imperative and paramount, primarily to let them know there is a cost savings, not just generally, but to their bill specifically for, and in a way that they can understand that they are benefiting from the transaction. And I believe that it would be helpful if the parties would work on that communication, and not just in fine print on some bill insert that goes in a trash can, but maybe a series of communications in a understandable way that that the ratepayer can read and understand that this is going to reduce their monthly bills individually. That is something that I think is important. I understand that other jurisdictions may do that when they do these securitization dockets, and there are probably some best practices out there in terms of how best to communicate that, particularly to someone that may not have an advanced degree, just someone that that is it just needs a simple explanation that this reduces their energy or electricity bill going forward in a substantial way. And if we could have that understanding, I think that would be helpful. Thank you.
Thank you, Commissioner Irvin. Commissioner Caston.
Thank you, Madam Chair. Ms. Moore, this bill, I'm on Duke Energy Carolina. Is this either three-page bill or like the second page that shows the billing details? Is this on a typical Duke Energy Progress South Carolina bill also? Or is this just unique to North Carolina, this detail?
I think we have the same format in both jurisdictions. Right now, we don't have, of course, we don't have the storm recovery charge yet, but I think it is similar, the important things to know.
Well, I might be showing a level of ignorance that's embarrassing to everyone. But when I look at my Duke Energy Carolina bill, I don't see all that detail, which I like. I like to see, rather than this number, like what's in that number. Kind of like here. Is that level of probably not a fair question, but is that level of detail in my bill and I've just missed it?
May I point out something?
Yes, ma'am.
I think this bill is on a time of use rate.
Yeah.
And perhaps your residential service is not on time of use.
Well, I noticed that, but, it has like the renewable energy rider. Well, of course, we wouldn't have storm recovery cost yet, and those kind of things. Do we have? Tell you what, let me withdraw that and just wait until the next rate case, and then I'll drill down in that. I'm wasting everyone's time on this, but thank you.
Okay.
I appreciate this.
All right, thank you.
Thank you, Commissioner. Commissioners, anything further for this panel? Hearing nothing. Mr. Spiros, Ms. Moore, thank you very much for your testimony and your appearance today. You may stand down.
Thank you.
Thank you.
Chair Belzer, may
Mr.
I have
Cooper.
a moment just to maybe redirect briefly?
Oh, I apologize that I left you out. I'm sorry, Mr. Cooper. My bad.
Just trying to make it the whole hearing without acknowledging I have to wear these, but Ms. Moore, you heard the questions regarding Exhibit 7 and the question on item 10 referencing 6.38%, correct?
I did.
And do you know whether the 6.38% is an after-tax weighted average cost of capital?
I'm not familiar with it, but it may be.
Mr. Spears, would you be able to agree with me that 6.83 is an after-tax weighted average cost of 6.38?
I also am not I'm not 100% sure, but it seems like it might be, yes.
And so then would it be possible that the 6.83 would be a non-after-tax amount?
Logically, mathematically, yes.
Okay. Thank you very much, Chair Belzer. I don't have anything further.
Thank you, Mr. Cooper. Ms. Moore and Mr. Spiros, you may now stand down. And Mr. Cooper, we would accept y'all clarifying that exhibit if you need to, and that's fine. It's just, I think when the numbers are like that, and it looks like it could be a transposition, I think that's what raised the question. So thank you. Ms. Brazil.
Good afternoon, Commissioners. Kristen Athens with the law firm of McGuire Woods.
I'm sorry. I called you by the wrong name. I apologize.
I thought you may have.
Yeah. I'm not having a good afternoon.
Duke Energy Progress now calls Mr. Thomas Heath as well as Katrina Niehaus. And as this commission is aware, Mr. Heath was previously sworn in, and his direct and amended rebuttal and settlement testimonies entered into the record, but he is available to be sworn in again if the commission would so like.
I think he's still under oath. I think Mr. Heath is still under oath. I'll just remind him of that, and I think that is sufficient. However, we do need to swear in Ms. Niehaus.
Ma'am, raise your right hand, please. Do you swear affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Niehaus, can you please state your name and business address for the record? And by whom are you employed and in what capacity?
Ms. Niehaus, would you please turn that microphone on?
There we go.
You're
All
on.
right. Katrina Niehaus. My business address is 200 West Street, New York, New York. I'm employed by Goldman Sachs, and I'm a managing director in the investment banking group there.
And how long have you been in investment banking?
19 years.
And how long have you been in your current role at Goldman Sachs?
18 years.
And are you providing expert witness testimony today on behalf of the company regarding utility structured finance as well as underwriting within the investment banking sector?
Yes.
So turning to your pre-filed testimonies, did you cause to be pre-filed in this docket on May 31st, 2023, 63 pages of direct testimony in question and answer form as well as 4 direct exhibits?
I did.
Do you have any changes to your direct testimony and exhibits?
No.
If I were to ask you the same questions today that appear in your direct testimony, would your answers be the same?
Yes.
And did you also cause to be pre-filed in this docket on August 10th, 2023, 12 pages of rebuttal testimony in question and answer form?
Yes.
That was amended on August 8th, 2023 to include only 8 pages of testimony?
Yes.
And do you have any changes to your amended rebuttal testimony?
No.
And if I were to ask you the same questions today that appear in your amended rebuttal testimony, would your answers be the same?
Yes.
Chair Belzer, at this time, I move that the pre-filed direct testimony and the amended rebuttal testimony of Ms. Niehaus be copied into the record as if given orally from the stand, and that her 4 direct exhibits be marked for identification as pre-filed.
Ms. Niehaus's pre-filed direct testimony and her pre-filed amended rebuttal testimony will both be entered into the record as if given from the stand. Ms. Niehaus's pre-filed direct exhibits 1 through 4 will be a composite exhibit marked for identification as hearing exhibit 15 and received into the evidence of this case.
And Ms. Niehaus, did you prepare a summary of your testimonies?
I did.
Will you please read your summary for the commission?
Good afternoon, Commissioners. My name is Katrina Niehaus, and I'm a Managing Director and the Head of Corporate Asset-Backed Securities at Goldman Sachs. I'm testifying today on behalf of Duke Energy Progress, LLC. I'm pleased to appear before you in connection with Duke Energy Progress's petition for storm securitization financing order. And by way of background, while these storm securitization transactions will be the first such transaction done in the state of South Carolina, these transactions are not new to the marketplace. Over $80 billion of rate reduction bonds have been issued successfully by or on behalf of utilities since the mid-1990s to recover authorized costs in a manner designed to provide significant savings to customers. The securitization process can result in a AAA-rated debt that is insulated from the bankruptcy risk of Duke Energy Progress so that the company's customers may benefit from a cost of capital that's based on a 99.5% AAA debt structure rather than a much higher regulatorily weighted average cost of equity and debt capital utilized in traditional cost recovery. This lower cost of capital could result in significant savings for customers, estimated at approximately $41 million as described by the company's witness, Smith. In my direct testimony, I described the process of how storm recovery bonds are marketed and ultimately sold through a public SEC-registered transaction to attract the largest number of investors and achieve the lowest storm recovery charges consistent with market conditions at the time of pricing and the terms of the financing order. I also explained the need for the financing order to afford the company the flexibility to establish the final terms and conditions of the storm recovery bonds. This flexibility will allow the company to achieve the structure and pricing that will meet the requirements of the storm securitization statute, including the lowest storm recovery charge consistent with market conditions on that day of pricing and the terms of the financing order. My rebuttal testimony explains that the company agrees with ORS witness Traska's recommendation to provide specific language in the financing order regarding third-party energy providers. My rebuttal also explains that the company agrees with ORS witness Traska's commentary that transactions exempt from registration would likely price at a higher yield than SEC-registered transactions, as well as his comments regarding ORS's preference for fixed-rate bonds as opposed to variable-rate bonds. As noted by ORS witness Traska and discussed in my testimony, I also stress how imperative it is that the company retain flexibility with respect to these issues and others in order to achieve the best outcomes for customers. Ultimately, it is my opinion that the company's proposed financing order, as well as the company's proposed structure and marketing of the storm recovery bonds, offer adequate customer protections and will achieve the objectives outlined in the securitization statute to the benefit of customers. This concludes my testimony summary. Thank you.
Thank you, Ms. Niehaus. And Commissioners, Mr. Heath also previously provided a testimony summary which did cover his direct amended rebuttal and settlement testimony. So at this time, I ask that Mr. Heath and Ms. Niehaus be available for any commission questions that you all may have.
Thank you, Ms. Athens. Commissioner Justin Williams? Or, I'm not sure whose light that is. Is that yours?
I forgot it was on, quite frankly. But I do have a couple of questions.
Great.
Ms. Niehaus, there's been much discussion about how the commission can determine whether or not the pricing of the bonds results in the lowest possible cost to ratepayers. How would you describe, or how would you suggest or offer for the commission a method to determine whether or not what is presented ultimately, if all this is approved, actually results in the lowest possible cost to ratepayers at the time under market conditions and so forth and so on?
The way that other commissions have gotten comfortable with that is through the statements that are made by your underwriter, so whoever that may be, as well as the utility, that they have achieved the lowest charge for customers. And so it is through that certification from the underwriters and your utility that you take comfort that we have in fact achieved that objective. Banks take that very seriously. It is not something that is done for any other sector that I am aware of. I work on bond issuances across corporations of all types, and this is the only place where we provide this level of certification, given the importance of achieving a good outcome for customers in the state.
Thank you for sharing that. You come across as very confident, and I believe that what you are sharing is true, and you believe that is true. And I have no reason to believe that it's not true. I just want to unpack it a little bit.
Of course.
What I've experienced is when someone has felt betrayed, or there may be some mistrust, that sometimes it's hard to believe even true statements, right? So other than the underwriter and the utility, how else would the commission be able to determine that the pricing of the bonds results in the lowest possible cost to ratepayers?
So the certification is what we work towards, which is what is required under the statute. I think if you look at your underwriting group broadly, the way that we are compensated and hired is that we achieve good outcomes for our clients and commissions. And so you have to believe that your underwriting group is going to be working to achieve the best outcome, because we are all incentivized to do that in order to get hired on the next deal. If there's a perception that the underwriter or underwriting group is not doing a good job, the consultants in the space would know that, and they would not recommend us for future transactions. And so it is in our best interest, as well as yours, to get to the best outcome possible.
Okay. I like that. That's good. Who are your clients?
My client in this case would be Duke.
Okay.
They would be the person that we signed an engagement letter with, and we are ultimately compensated through bond proceeds.
Okay. So I want to clarify something. When I reference mistrust and being hurt, generally speaking, I'm talking about, in my experience in the commission in this space, I've seen that sometimes there's general mistrust perceived based on whatever those reasons may be. And I would like to see if there's a way to show and prove that there's no need for concern. So I hear that you have a duty, at the very least, to your client, Duke. I hear that. You mentioned the commission, but I'm not really sure, other than us accepting the or approving the issuance, I'm not really sure how we fit in that relationship. How would you assess the commission's happiness or position on the issuance? Is it simply just based on how we vote, or is there some other way you gather that information?
So there's been about 80 billion of these deals issued since the 90s, and the commission's approval of these transactions is through the approval of the issuance advice letter.
Okay. So if we approve it, then the assumption is we're happy with the outcome.
Yes.
Okay. So it seems then, based on what you shared with me, that there's a certain amount of trust that's inherent in this process.
In all processes like this, there is going to be some amount of trust. There is no empirical way to, no numbers that you can line up to show that the outcome is has been achieved. It is all about the trust that you have with Duke, the trust you have in the certification, the trust that you have in the legislative requirements, which if we were to be hired as an underwriter, our goal would be to meet the legislative requirements and achieve a successful outcome and closing of the transaction.
Understood. I accept that. And Mr. Heath may want to chime in. So trust is key. And there's no reason to believe that anyone involved in this transaction is not trustworthy. So I trust in that. Is there anything you can offer me that, in addition with my trust, gives me the opportunity to verify?
The certification, which is legislatively what is being asked for.
Okay. And that comes again from the underwriters, correct?
Correct.
Okay.
Well, can I add? I mean, you add.
Sure. Yes, sir.
So, there's more than certification from just the underwriter. So we've proposed in our application, our petition, is that the certifications come from the company, the underwriters, and from the qualified independent third party that's provided for in the statute. And so we believe that the existence of that qualified independent third party and the requirement in the statute that there be some form of pre-bond issuance review process, which we have proposed a bond advisory team that includes participation from, or includes membership from the ORS and participation from the underwriters and the DCA in that process, that they will give advice and input on pretty much every aspect of structuring, marketing, and pricing these bonds from the time we receive the financing order to they're actually priced and we come back to you with an issuance advice letter. That whole process, that the ORS and the DCA's involvement in those bond advisory team proceedings and the certification from the QITP, certifications from the company, certifications from the underwriters, whoever they may be, would provide you with a high level of comfort that if we issue those certifications saying that we achieved quantifiable benefits for customers and achieved the lowest statutory or lowest storm recovery charges consistent with market conditions at the time we priced the bonds, that would give you a very high level of comfort in approving the transaction.
Understood. And I remember your testimony from earlier. That seems like 10 years ago, to be honest with you, the last time you were on the stand.
Yes, it does. Yes.
But what I'm hearing, listening to you all's testimony together, it seems the protections for the ratepayers and the verification for the commission is baked into the process. So if everyone does their part in the way that you contemplate, then we should be able to review that information to verify that indeed the issuance results in the lowest cost of ratepayers. That's the way it seems. And I can't remember, but when we are asked to approve the issuance, what all information do you contemplate we will receive? If you could remind me. You may have testified to that earlier, but if you did, please excuse me. I'm asking for a reminder. Remind me what information will come before the commission if we approve the stipulation and all that work that you just discussed, the pre-issuance review process and so forth and so on. When you come back to us to approve the issuance, what information will we receive?
Sure. So I'll point you to In our petition, I believe as an exhibit to the financing order, we provided a form of the issuance advice letter. And so you can kind of see what that's intended to look like. And so some of the things that'll be in that issuance advice letter is the total issuance amount, the term that we issued over. We've been talking about a 20-year recovery period, the interest rate achieved on those bonds, the proposed amortization schedule, the certification from the company, and then attached to the whole process or delivered a day after our issuance advice letters, the certifications from the QITP. The underwriter certification, I believe, is being delivered the same day we deliver our IAL. There's also in there the calculation of the revenue requirement and the storm recovery charges by customer class that Witness Moore talked about in her testimony. And then there is a fairly lengthy narrative that will kind of catalog everything that we've done from receipt of the financing order to the issuance of the bonds. So we achieved ratings.
So let's slow down there, because that's really what I want to talk about, that fairly lengthy narrative. Will it include minutes or some reference to the meetings or whatever that bond advisory team does and the issues that are discussed? Or you and I went through a little discussion about who gets to decide what's the issue, what's the non-issue, all those things we discussed earlier. I believe it was Monday. Will that be memorialized in any way?
Some of that will. I mean, we'll talk about how many times the bond advisory team got together, at a broad level, the discussions that were had, which is really every aspect of the structuring, marketing, and pricing decisions from the time we receive financing order to the time we price the bonds. And then, so it really kind of has that. And we met, weekly, we met semi-weekly or whatever the frequency happened to be. We believe it was a very cooperative and free-flowing discussion of ideas and those sorts of things. When we accepted advice and input of ORS and DCA as it was offered. We won't necessarily catalog in there, were there specific things that we'd put in disclosure materials because of a comment from ORS. It won't be that specific, but we'll talk about.
Well, let me ask you this: any prohibition on it being that specific? Because I don't know if any of this stuff's going to come up or not. But in terms of verification, potentially it could be helpful to know that objections were raised, they were addressed in a certain way. Just a full memorialization of the process to verify that, and not that you would not do the work, but that you all are doing the work, that hard, difficult work.
So, I would have to consult with my attorneys to figure out how specific how comfortable we would be with a level of specificity in there around specific discussions that were had. What I would point to is that, in the settlement agreement, the parties agreed for ORS to serve as the qualified independent third party. And so they're an official member. We had this discussion on Monday about official member versus participating member. And so ORS is proposed to be an official member of the bond advisory team along with the company. And they're proposed to be the QITP. And the QITP is given a certification. So I think we get back to that idea that if there's significant disagreements around philosophies or discussions, we will work that out through the bond advisory team process so that we can be happy that ORS as QITP, as we've proposed, and the company and the underwriters are all going to be comfortable providing their certification at the end of the day. So I think that helps to support that what may only be a few sentences in the IAL about frequency of bond advisory team meetings and the broad concepts and things that were discussed there, because ORS is going to have a very strong voice in this, and DCA as well. But I mean, both of them will have a very strong voice. ORS as the QITP as a certifying party, has a very, very strong voice, and I don't discount DCA's voice by saying that, but their role as a certifier, as a QITP, should give that level of comfort that they were in agreement on at least all the material things that affected the outcome of the transaction. There might have been some small disagreement about the phrasing of a particular disclosure matter or the presentation of a specific point in a rating agency presentation or something like that. But if those things are not to the level of, we think this materially affected we think it's affected the outcome of the pricing, I would not expect that the QITP would withhold their certification for that.
I have no idea. I just want to make sure that if someone has an objection or if there is a issue, that I get to, and maybe there's an argument that the commission doesn't need to know that. I don't know. I'm working through it with you to try to, because I trust you, but I also have to do my job and verify that what you're saying is actually true. So if I'm responsible for ensuring the lowest possible costs, it seems as if I'm required to take somewhat of a leap. No disrespect to you, ma'am, sir, or anyone involved in the process, but I have to take somewhat of a leap just relying on a letter alone, or several letters. So that narrative at least gives me a picture after it's all done of what happened, and if issues were raised, how they were resolved. And what I'm hearing you say is that there's no prohibition in including something like that. I know you got to talk with your lawyers.
Again, I would have to talk with my counsel to understand, what level of specificity we would be comfortable putting in that sort of document.
Because if I remember correctly, on Monday, you all are the leaders, right? You're the team leaders for the bond advisory team. Is that fair to say?
I would say we're the decision maker on matters of disclosure or matters of on structuring marketing and pricing aspects, but in consultation and with advice and input from the other members of the bond advisory team, be they ORS or DCA or the underwriters.
And it
is a team effort, but it is ultimately Duke needing to be in a position to make disclosures around things that could subject us to legal risks.
Right. And you're going to draft the narrative, or someone on your team is going to draft that narrative,
Correct.
Right? Okay.
And that narrative will be reviewed by the bond advisory team.
Do they get
before it gets filed? So we are proposing a draft issuance advice letter that we would provide to the bond advisory team. I think it's a couple weeks before we actually launch the transaction, so they'll see at that time what we think we're planning to say.
Mm-hmm.
The details will be worked out in terms of the pricing and the amortization schedules and all of those once the deal's priced. But they'll be able to see that narrative and provide advice and input on, is this sufficient?
Mm-hmm.
We need to update this wording. We need to elaborate here a little bit. But so they'll have that input in that process as well.
Okay.
And then they will receive the final issuance advice letter as well.
Okay. All right. Thank you, Ms. Newhouse and Mr. Heath, for going through that with me. I greatly appreciate it. Madam Chair, that's all I have.
Madam Chair.
Thank you, Commissioner Williams. Commissioner Irvin is recognized.
Thank you. Is it Ms. Hightower? Is that correct?
Niehaus.
I'm sorry. Apologize. I missed that. And you've worked with Duke on other bond matters. How many have you worked with them on in your 12-year career?
Personally, I have not worked on a Duke utility securitization. Our firm does do business with Duke outside of utility securitizations in your sort of regular way bond offerings, but that would not be me or my team.
Okay. Do you know how many bond issuances Duke has engaged your firm to handle as underwriters?
I do not.
You don't have any idea?
I don't know. Tom, would you know?
I don't know offhand. I would say that Goldman Sachs is a regular underwriter for Duke on first mortgage bonds, for holding company unsecured bonds. So it would not be uncommon for them to underwrite one or more transactions during a year with the level of debt that we issue as an enterprise, $7 billion or more annually.
Right.
So it would not be uncommon for them to be an underwriter.
It's fair to say that Goldman Sachs is your go-to underwriter.
I wouldn't describe it that way. They're maybe one of our many go-to underwriters. We have a master credit facility that has a number of financial institutions. I believe it's 25 or 26 different financial institutions participating in that credit facility, providing Duke with liquidity and financial support in various aspects. Underwriting debt issuance is being one of those. And all of those 25 institutions in some capacity get cycled through bond issuances and equity issuances.
Thank you. Has Duke put out a request for proposal for underwriters to handle this bond securitization?
Not at this stage. We did an RFP for the role of structuring agent, which is the position that Goldman Sachs is currently serving in. So we did a solicitation January, February maybe of this year, and Goldman Sachs through that solicitation process was selected as our structuring agent, but we have not decided in any capacity on underwriters for this transaction at this point in time.
Wouldn't it be reasonable and prudent to do a request for proposal from other underwriters to try to hold down the cost, underwriting fees and costs that are incurred that will be passed on to ratepayers?
What we have reflected in terms of underwriting cost in our upfront expense exhibit is, I think, a range of 40 to 45 basis points of underwriting on the principal of the bonds issued, and that's consistent with what we paid to underwriters in North Carolina, I believe even in Florida 7 years ago or so. And it's consistent with what we've seen being paid on more recent securitization, utility cost recovery bond transactions since our November 2020 issuances for DEC and DEP in North Carolina. So that level of aggregate fee is consistent with what we've seen. I believe we had some discussion around, what in our RFP for the structuring agent role, what we could expect to see in terms of underwriting fees on this transaction, and that came out in that 40 to 45 basis point range as well. So, we will consult, we will seek the advice and input of the other bond advisory team members once we get into that phase of the transaction, assuming we get a financing order here, and that may very well be a competitive RFP for the underwriting services for the bonds.
Now, in terms of the process itself, is it fair to say that, and I'm asking our Goldman Sachs representative, that Goldman Sachs would not be issuing an unqualified letter to this transaction? Is that correct?
I'm not sure I fully understand the question. Is the question about the certification?
Yes. Is it going to be unqualified certification?
We would follow the statutory requirement, and to the extent there was a major qualification, it would be unlikely that the group would decide to move forward.
The underwriter, if it happens to be Goldman Sachs or whoever it is, the underwriters have no fiduciary duty to the Duke ratepayers, do they?
Underwriters do not have a fiduciary duty to ratepayers, no. But the way that commissions in other jurisdictions across the $80+ billion of issuance have gotten comfortable with the outcome for ratepayers is through the certification requirement in certain states.
Well, you mentioned Florida. The Florida Commission had a provision in its issuance that if there is an impasse between Duke and the qualified independent expert, there was a dispute resolution mechanism, but that's not in our in your proposal here, is it? You don't have in other words, Duke retains the right to make the final call without exception, right?
That's correct. The statutory, the statute and the financing, or the statute in particular in Florida, different from the statute here in South Carolina. I believe the financing order, the bond advisory team construct was different there, specific to the statute. What the statute, the securitization statute itself, as well as the statutes and the rules and regulations governing the commission. So we used both the Florida and then our North Carolina precedents as the starting point for what we proposed here in South Carolina, and adapted that for specific, unique statutory circumstances in South Carolina.
But when the ultimate decisions are made, only the company and the underwriter make the final judgment. You can listen to others on an advisory team, but the ultimate decisions about the type of certification, resolving any disputes that may arise on the bond team, all those things are solely in the discretion of Duke, correct?
They are in the discretion of Duke. I do want to maybe just, I don't say correct something or clarify something that you said. I think at one point you mentioned in the discretion of Duke and the underwriters. I want to make sure we're clear that the decisions are in the discretion of Duke, with advice and input from all members of the bond advisory team, including ORS, DCA, the underwriters. But the decisions are Duke's, not Duke and the underwriter, not, so it's Duke's decisions with advice and input from all members of the bond advisory team.
I understand. But wouldn't it be best for South Carolina Duke ratepayers that are going to be on the hook for 20 years for repaying the bonds, wouldn't it be best for them if they had a representative in the room where it happens, where those decisions are made, have some input?
They absolutely have a voice in the proceedings through the participation of ORS and DCA on the proposed bond advisory team. And one of those parties being ORS, as we're proposing in the settlement, would serve as the QITP. So they would have two voices. Residentials would have two voices representing them, DCA and ORS. All customer classes have ORS representing it as a certifying party. So customer voices are represented in this proposed bond advisory team process.
Yeah, let's delve into that just a little bit, because our statute in South Carolina says that the South Carolina Public Service Commission designates the qualified independent expert. And you've chosen to take that away from the commission and under your proposal, and you've chosen ORS. And I'm curious as to why you did that, because it's clear in the statute that commission has the right and the responsibility to select qualified independent expert, correct?
I believe, excuse me, I believe Chair Belzer the other day made a distinction between designating and selecting, or designating and appointing.
Yes, it's our
And so,
duty to designate, right?
and that designating could occur in various forms. And so, the commission has the ability to designate ORS as the QITP through the approval of the settlement agreement. If you don't like the settlement agreement in total, then I would say you don't approve the settlement agreement in total.
Yep, and that's one of our options for sure, because, and here's why. The Office of Regulatory Staff is required under law to protect the public interest. Let's assume that they say that they conclude that, yes, there are quantifiable benefits to ratepayers if the transaction goes through. You with me so far?
That's step one. Quantifiable
That's
benefits
step one.
is the
Correct.
the first statutory requirement.
That's right. However, the commission is required to go further in that evaluation process because we're required by law under the Securitization Act to find and conclude, as a matter of fact and law, that the customers affected by this transaction get the least cost benefits.
The statutory requirement, I believe, is lowest storm recovery charges consistent with market conditions.
Right.
And you'll have certifications from the company, from the underwriters, from QITP, that will help you make those findings of facts, I believe.
But under current market conditions, kind of as an escape lane for everyone that wants to proceed, it doesn't answer the ultimate question is, are we getting the least cost for ratepayers in the transaction, does it?
I think unless anyone up here has a crystal ball and the ability to project forward what's going to happen in the market in the next 3 weeks, 6 weeks, 2 months after a transaction. And by the way, if I could do that, I'd be sitting on the beach in Hawaii. I wouldn't be up here testifying in front of you all. No one has the ability to know what a transaction would look like if we waited 2 weeks. And so because of that, underwriters need to qualify that they achieved the lowest charge for customers based on market conditions at the time the issuance was done. There's no ability for anyone to be able to forecast what might happen. Might Russia invade the Ukraine? Might China invade Taiwan? Might we have a rate, might interest rates be adjusted up or down? None of us can forecast any of that. And so the qualification for the lowest charge for customers based on market conditions at the time of issuance relates to that exact fact. None of us have a crystal ball and none of us are able to forecast or change the market conditions that we're living within.
I understand. But again, ORS is not the ideal candidate for serving as the independent qualified expert because
Chair Belzer.
they're conflicted.
Mr. Austin, just a second, Commissioner.
Sorry, I just need to object to this line of questioning. These witnesses don't have any sort of personal knowledge as to the qualifications or abilities of ORS.
Well, we do, and I think it's proper questioning, Madam Chair, if you allow me, please.
Let's start wrapping it up, if you would, Commissioner.
Okay, thank you. So just to cut to the chase, we heard Mr. Rothschild's testimony that he didn't believe that a state agency attorney that's never been through a securitization transaction is qualified to serve. You heard that testimony, didn't you?
Objection, Chair Belzer.
Mr. Austin.
I believe that misstates the testimony of Mr. Rothschild.
I would concur, Madam Chair.
Sustain.
and other jurisdictions that you've worked with, including Florida and North Carolina, did who was the independent qualified expert for the commission in Florida?
In Florida, the commission consultant, I believe, would have served that role, and that's again a different statute, different state. In North Carolina, but I would say that I don't know, those don't really fit the bill of equivalent to the qualified independent third party in South Carolina. I think if my read of the statute seems to be that the legislature may have, the legislature clearly said that the ex parte rules that this commission abides by in every other proceeding applies to this proceeding the same way it does to any other proceeding. And it also said that maybe I think it's our briefs that were filed says that the commission consultant would need to abide by the same ex parte rules as the commission itself. So I think if we look at the statute with the ex parte rules in mind, which the legislature, I believe, is clearly aware of, that this commission has to obey those ex parte rules, quite likely could have put in this role of QITP. I'm not familiar. If you look at other statutes, I don't know that there's the concept of a qualified independent third party in other statutes. So I think the legislature was aware of the ex parte rules governing this commission and likely created the role of the qualified independent third party to be someone independent of the company, independent of the underwriters, to represent the customers, in this case, in this proceeding.
And in its wisdom, the South Carolina General Assembly specifically designated in the statute that the Public Service Commission of South Carolina shall designate qualified independent expert, which is not what is happening in our so far in our in your presentation. You're not following the statutory provision. You're aware of that.
I disagree with that. We reached a comprehensive settlement agreement amongst all the parties in this proceeding, and as I stated a couple of minutes ago, the designation of the qualified independent third party could likely occur in various ways. And then one of those could be through the acceptance of the settlement agreement that's being put before this commission.
And another way would be for
Chair
the commission to designate
Just,
its own.
Commissioner, just a second. Ms. Athens?
I'm sorry, I was letting Mr. Heath finish answering the question, but I just want to note that I object to the form of the questioning that Commissioner Irvin just made regarding the statute and the form of the settlement.
Objection comes too late. It's been asked and answered.
It is a bit late. Go ahead, Commissioner.
Thank you. Those are all the questions I have. Thank you.
Thank you, Commissioner Irvin. Commissioners? Commissioner Thomas?
Thank you. Good afternoon. So there's been some discussion about the certification or the opinion and the qualified or unqualified. And in my opinion, it is critical that in order to proceed, then there should be unqualified opinions, certifications from all of the parties. Do you all agree with that?
As Ms. Niehaus was just saying in response to questions a couple minutes ago, I mean, those certifications have to recognize the fact that a transaction was in the market on a particular day with the particular market backdrop that existed at that point in time. I don't think we can look at, what would be the outcome? As she said, what would be the outcome 2 weeks from now, 2 months from now, if we delayed? I also don't think if we can look at what would have, if we're going through diligently and we're addressing the rating agencies and the SEC and we're doing our marketing in a timely manner, we also can't look back and say, oh, I wish we would have gotten to the market 3 months ago. These things take time. From receipt of financing order to issuance of the bonds takes several months. We've got to go through the rating agency process, the registration process at the SEC, the pre-marketing and the launch of the transaction, and those things, they don't necessarily have to be all sequential, but they do have to follow an orderly manner. And so we have to assess the right time to put the transaction in the market, and we have to certify as to the conditions when we had that transaction in the market and whether we got the lowest storm recovery charges consistent with market conditions at that time. Not months before when we couldn't accelerate our schedule that much, not months after when we don't know what the horizon looks like.
I understand all of that, but my point is that the opinion or certification happens right there at the end when it's our turn to make the decision. And it takes into account what's going on that day and everything else. It's a matter of, did everything go not necessarily according to plan, but did everything play out in a manner that the parties, all of them, can issue an unqualified opinion? I believe that's a little bit different from the scenario you just went through.
I guess, what do you mean by an unqualified opinion? You mean you want to remove the at the time based on market conditions qualifier?
No, I'm not here to answer questions, but so here's the deal. It's kind of like in accounting. The accountants will issue qualified and unqualified opinions, and the unqualified opinion means everything's all good. If it's a qualified opinion, then that means, okay, there's maybe the company didn't record their bad debts the way they should have. So the point here is unqualified means everything's all good. Unqualified opinion is important. Do you all understand that?
I mean, I think the expectation is people will issue a certification letter that meets the statutory requirement, which is lowest charge for customers based on the market conditions at the time of issuance. And that to me would be an unqualified opinion or letter.
So long as there are not other things in there that are saying, well, somebody didn't do something right. That's the point. And I think that the unqualified opinion is going to be very important. And I do hope that you can kind of understand where I'm coming from on that.
I definitely understand your line of questioning and your concerns. And I'm not sure we can fully sort through what unqualified means, but I get your line of questioning around. Yeah, we're not going to have comments in this issuance advice letter or our certification that's going to say lowest storm recovery charges consistent with market conditions, except for if we had done this, except for something else, except for something else. There's not going to be those kind of qualifiers in there, but the qualifier that this is the lowest storm recovery charges consistent with market conditions on the day we priced this bond, with all the things that led up to there. So it's not just, it's reflective, it's issued at a point in time. It's issued when the bonds are priced, the day after the bonds are priced. But that certification and that issuance advice letter is the culmination of everything that takes place from the receipt of the financing order from this commission to the pricing of those bonds. So it's not just this point in time. It's through that entire 4 month, 6 month process, whatever it happens to be.
I think you're right, and I agree. It's the whole process. Madam Chair, I thought we had a timeline where we had.
We do. We need to stop in a few minutes. Are you at a good stopping point, Commissioner?
As good as any.
Okay. Ladies and gentlemen, we need to stop by 4:30, and so I'd like to pick back up at 9 a.m. Is that going to be problematic for anybody here? Okay. Thank you. We will recess this hearing until 9 a.m. tomorrow morning.
Chair Belzer, and we can certainly take this offline, but assuming that the commission will be able to accommodate any witness availability issues that arise from not finishing today.
We can talk about that, but witnesses, I would like to caution that you're under oath and ask that you not discuss your testimony with anyone or allow anyone to try to discuss it with you. Thank
Understood.
you. Yes, we can deal with all parties on any witness availability issues. We're in recess until 9 a.m. tomorrow. Thank you.